CEPA is one of the toughest whistleblower laws in the country. And if you're a business owner in New Jersey, one wrong move could really hurt your future. I'm here with Anton Kaminsky, Kaminsky Law. What is CEPA and what do employers need to know?
So CEPA is a policy or a law in New Jersey that really protects employees that report what they reasonably believe to be unlawful activity.
Okay.
We should really take a minute to talk about what an employer can do or a company can do to avoid kind of the grasps of CEPA.
So I would say the first thing to do after you watch this video is go also watch the employee-focused version of the CEPA video, because I think employers should know what employees should know so that they can better protect themselves and do the right thing. But let's jump into this topic here. Really, I guess the first thing is don't do wrong stuff, right?
That's the low-hanging fruit, right? Low-hanging fruit is don't do anything illegal.
Don't do illegal stuff. See you later.
Bye. See you guys.
Great episode. So what should so after they don't do the illegal stuff, right? What should employers know? Because thinking back to the other episode, employees can come forward on things that they believe to be illegal, right? And so first, what is the process or expected process of a whistleblowing activity in a business? Let's hit that first.
Okay. So the first thing that you could really think about doing as an employer or a company is to have a well-documented and a well-circulated employment reporting policy. Okay. Right? And so if your employees don't have a handbook or don't know where they can go to, that's not great. If your handbook doesn't say anything about reporting what you believe to be unlawful activity, that's also not great. Yep. So, one of the things that you could do is as you start to grow from a smaller company of, a few employees to a larger company is become a lot more standardized, and to have a employee handbook that says, we take CEPA seriously. Yep. If you believe that something unlawful is happening, this is what we want you to do. This is who we want you to talk to.
Got it. Okay. So create a process and policy, make sure it's in your handbook and make sure everybody knows it so that they know that they can be comfortable to come forward. I think one of the things that we really differentiated in the other episode where we were talking to the employees on CEPA is, I think a lot of times you have this thought in your head, and most employers are probably watching this and really concerned that the thing you're worried about is someone's going to whistleblow. And usually when we think of a whistleblower, it's like a news story, right? Somebody comes forward and they go, I'm broadcasting this to the whole world. What really happens in most, large, medium, and small size businesses is that somebody thinks something's going wrong. They come forward to their manager, the CEO, whoever. But then instead of that person just going, no, this isn't illegal or wrong, or yeah, you know what, you might be right, we need to change this process, they do something else, right? And that's what CEPA is really protecting against.
Right, yeah. An employee can report under CEPA or meet the reporting requirement under CEPA very easily. They could write you a text. They could write you an email. They could say it verbally. Hey, I don't think I should be doing this. And it's not just an employee that has to lay out everything that they think is illegal. It's enough for the employee to say, hey, I think that the way we're billing isn't correct. It might be illegal, or we might be doing something that's not proper. And if they say that they think that it is, if they say that they, refuse to participate in it, or they think that we shouldn't do it as a company, you really have to take that seriously.
Yep. Okay. So that's the first thing.
That's the first thing. And the second thing is, a lot of times as an employer, what you're going to have the inclination to do is, well, this employee doesn't know what they're talking about. Let's just have them do something else, or let's wall them off from this process. And I think that almost immediately gives this, this perception of retaliation. Well, I used to do this billing, and now I told them that I didn't think we were doing it properly, and they immediately took it away from me. So that's almost creates a hook right away.
Right. Okay.
And so as an employer, you really want to be careful about your immediate reaction. And again, it's a lot easier for a bigger company because they're so compartmentalized and they have some different departments. And we could talk about what a bigger company can do differently than from a smaller company. But from a smaller company, usually the person that's reporting is reporting to the CEO because there's not much of a hierarchy.
Right.
And so as the CEO, you got to not have this visceral reaction right away.
And so, right, because I think that it's easy to get emotional, right? It's easy to go, I can't believe this employee is, has the audacity to claim I'm doing this. We're assuming we're not taking the ones that are doing the wrong thing, right? Again, at the top of the episode, don't do wrong things, right? But but if you think you're following the proper billing practices, use this as an example, and I think you've used an example in defrauding Medicare, right? You were saying that like if you're a business that is maybe submitting claims for insurance and things like that, and the employee thinks there's a discrepancy in terms of what we're reporting and how we're reporting it. You think you're doing it correctly, they think you aren't, right? That immediate reaction of this employee is not loyal, this employee is accusing me of things is probably going to be mostly driven by emotion and make you want to do things that are not probably going to serve you well in the long run, right?
Yeah. I also think that there's a medium between we're not doing anything wrong and we knowingly are doing illegal stuff.
Right.
There might be an in-between where, hey, I didn't know I couldn't do that, right?
Right.
The old Dave Chappelle joke.
Yeah.
Didn't know I couldn't do that. And so it's possible. It's possible that your employee found something that you didn't know that you couldn't do that you're doing. And so ideally, the proper course of action is to say, oh my God, you're right. Let's correct this.
Right.
And then, if we're talking about defrauding the government, for instance, the government takes it a lot more lightly. If you find out that you did something wrong, you say, oops, we didn't know we could do something wrong. You self-report it and you go, here's your money back. They won't send you to jail.
Right.
Unless it's nonsense, but they usually won't, retaliate against you if you come forward on your own.
Right. So there's definitely an inherent incentive to do the right thing in general.
Right. And then, so the other thing that you should really be thinking about is, there's two things. One is to really separate the person that's investigating the illegal thing or the allegedly illegal thing from the person that's in charge of making an employment decision about this person. Okay. So separation of church and state, so to speak, right? Because it's so easy to say, I told my boss that we were doing something that I thought was illegal. And it was then my boss that investigated it and said, no, we're not doing anything illegal. And then it was my boss that fired me.
So what do you do if you're, a small company, 10 employees, you're the CEO, most of everybody reports directly to you, and you don't have somebody to institute this separation of church and state?
So one of the things that you could potentially do is to, appoint a committee, right? People are like committees, right? But really like, hey, here's these 2 employees or 3 employees that we have. This person made a report. Obviously, they made it to me as the CEO. Obviously, I'm the one with the ultimate decision. But we're gonna have these 3 people look at this to see if what you're investigating is correct.
Okay.
Right. And so now it's almost like detached a a bit.
So it creates a little transparency spread. Now, couldn't that be interpreted though as like they're defaming me, and I came to the CEO, and now the CEO is telling everybody that I'm this whistleblower, and he claimed it was by committee, but it was really just to shame me, right? It could create another problem, right?
And there you have it. So you go to an outside person, maybe a lawyer.
Okay.
Hey, we've received your complaint. We don't know if this is proper or improper, or we don't think it's improper, but we hear you loud and clear.
Yep.
We're going to take this to our law firm. We're going to take this to our lawyers. We're going to take this to our accountants. Maybe we'll take it to an expert in this field and ask them to look at what we did. And now it's an independent third party, so to speak, that does the investigation, so that it's really not the CEO going, nuh-uh.
Right. Okay. So you do that. There's all kinds of, where my head goes to, okay, so what are the other steps? Let's go through those steps first of what are the right things to do, because I've got in the back of my head, and so for people that are listening and probably thinking the same thing, okay, well, what if this is just a bad employee that's pulling some stunts because they know they're probably on their way out the door, right? Which is the other side of this, right?
Right.
The whole reason CEPA is in place is to protect whistleblowers from retaliation. The reason there's retaliation is because sometimes employers are doing incorrect things or just get mad because they don't want to hear it and they want to get these people out of their life. But sometimes the other side of it, and we don't want to victim blame or any of those things, but sometimes the other side of it is these people have a different agenda as to why they're doing it, right? So before we get to that, I think what probably makes sense is let's finish quantifying or qualifying what the employer should do as best practice. And then we'll probably get to the place of, if you think this person's a problem, here are the steps you can take so that you don't end up in a CEPA.
Yeah. So as best practice, I mean, the other things to really touch on is if there is somewhat of a hierarchy, right? And it's not just everybody reports to the CEO, it's to make sure that your supervisors know how to act so that the second that they get reported to, they send it up the proper channels,
right.
and they don't start, criticizing or ostracizing that employee right away.
Sure.
Right. The other thing that you can do is, process wise, if you're a bigger company, is really to separate these things. Right. And so, maybe there's an HR department that you reported to that really doesn't have much say about whether or not this employee gets fired or gets, any sort of employment action gets taken against them because they're not performing their job well, is to have this separation of the people that you report it to. And again, put it in your policies. Or like, here's your line of reporting. Yes, you want to report it to your supervisor, fine. But if your supervisor doesn't do what they should do, the next person you should report it to is HR, which is now a disconnected kind of entity that hopefully is going to review this independently. And it won't be the same people that are saying, oh, well, this person sucks at their job, that's why they're reporting this.
Sure.
Right. And so that's another, that's another kind of best practice. Another good practice is call your lawyer, right? As a lawyer, we're incentivized to say this, but if an employee refuses to participate into something or they start objecting to something, before you take matters into your own hands, talk to a lawyer and say, hey, they reported this. This is the context that they reported it. And what do we do? How should we approach this? And to answer your question, which I think is really the meat and potatoes of this discussion from the employer standpoint, is almost always the defense for the employer was this person was not great at their job. They didn't want to be here. They were already getting kind of written up for other things. And so as their last ditch effort to find a hook to sue us for something, they reported something that they thought was unlawful. It wasn't unlawful, but now we can't fire them because they've reported
and we're
this.
Stuck. Right.
And so what do you do in that sense?
Yep.
And, again, ideally, the best practice is that your people that are reporting that your employee is doing something wrong and the documentation of their, bad work ethic or improper work conduct is already in place, right? And so the big lesson here is don't wait to, if you have an issue with your employees, start documenting that issue so that then if you come to a lawyer later and you say, well, this guy or girl was not a great employee, and here's all these records from before they reported anything, now you have a much better defense.
Yep. So that comes down to process, procedure, policy, probably having talked to an attorney beforehand when they drafted your handbook, right? We have a couple different things there about, one, making sure that everybody has the handbook, two, that the information about reporting and the procedure for that is in the handbook. Three, that you're following those procedures if you're documenting an issue with an employee so that if, God forbid, something like this happens, you can go to an attorney and go, look, I followed all these steps. They had the handbook, they knew who to report to, and also I've been documenting their issues. This is fraudulent. Because you've talked about and used, to quote you, the range of reasonableness in terms of CEPA is like a Mack truck could drive through it. Are you still kind of in a stuck position because CEPA is so protective of the employees that, like, as an employer in New Jersey, even if you do all these things correctly, you're still running a risk?
A little bit, yeah. So there's a couple of things that, like, you don't want to do. Number one is an employee comes in and reports something and then, oh, well, here's this performance issue that you have. So they reported something to you today, right, and then a week from today, here's this performance issue.
That's like definition of retaliation.
Right. And so if there are, again, this goes back to what I said a minute ago, is if there are performance issues, it's important as an employer to kind of really keep track of those contemporaneously, even if they don't necessarily go directly to the employee.
Yep.
Right. So if you have, other supervisors at your company or other employees, and you even write them an email and say, hey, so-and-so hasn't come to work. We haven't counseled them about it. Or, they're doing a really bad job. We haven't counseled them about it, but I think we might have to lay them off. And you have this employee, you have this, email that's 2 weeks before this person first reported anything.
Yep.
Even if it didn't go to that person, that's already a good kind of piece of evidence. The other thing that you really want to do is, if you're going to have to terminate this employee either way, is you want to make sure that there's not going to be, it's going to be very hard to establish there's a causal connection between what they reported and what you terminated them for. So again, building the record, number one. Number two is the people making the decision about whether or not what you're doing is proper.
Yep.
Versus whether or not we should terminate this employee should be different people that should really be walled off and
Right.
not talking to each other about it, right? Those are really good ones. The other one is really kind of having a lawyer kind of give you the roadmap and
Right.
make sure that they know the facts. They kind of give you, hey, maybe you can't terminate this employee for 6 months now. Maybe you're stuck. And maybe that's a better stuck than
what
getting
the cost
sued
would be,
for
right.
it, And the other thing that you can do is to perform an investigation, to perform a real investigation and say, hey, we didn't find anything and we're terminating you because your performance is bad, right?
Right.
It's an outside investigation. The last and I guess most important thing that you should do, and we've covered this a long time ago, but we should cover it again, maintain insurance. You have to make sure you have the right insurance.
Yep.
As an employer in New Jersey, it is imperative that you speak to your insurance brokers or you review your insurance policy to say, hey, are we covered for CEPA claims? Are we covered for, are they errors and omissions claims in New Jersey? Are they employment claims in New Jersey? If we have an employment policy, is CEPA carved out of it, right?
Yep.
That's a very important thing, is check your insurance, make sure your insurance covers you for this, because look, sometimes accidents happen. Sometimes, you got rid of the employee for a different reason and the reason, but the employee doesn't think so. And some lawyer on the other side of it doesn't think so. They're going to bring the claim anyway. You want to try to have coverage.
And does that coverage, I mean, this is probably an insurance question that's outside the realm of our conversation, but because one of the things we talked about in the employee-focused episode, where you talk about the CEPA protections for employees and the steps that they could take and how this works for them, one of the big things is that if the claim goes through, it'll cover their attorney's fees, right? There's all kinds of provisions for employees. It's not the case for employers, right? The employers don't get protected or are able to get coverage for their their legal fees, I assume. And so these are all just expenses to them. So as an employer, right, having insurance, having those things to cover, right? And that's kind of where I'm asking, and maybe this isn't your area of expertise, but does that insurance even cover those things, right? It might cover the claim and if there is wrongdoing found or discovered in a court, which might not be accurate, but it's the claim that the court found. But does the insurance cover all the lead up?
A couple of interesting things. So number one is, if somebody brings what a court later determines to be a non-viable or frivolous CEPA claim, you actually can try to get your attorney's fees as the employer.
Okay.
You go back after the law firm that filed the lawsuit. Now, you're probably not going to get all of them, but you might get something. That's number one. Number two is, and this goes into the insurance discussion, but let's say I have $1 million in coverage, right? An employee is suing me for $100,000, and I'm going to you then maybe want to get a lawyer involved to oversee your insurance company to say, like, hey guys, you guys can take this thing to the wire. This person could get awarded $100,000 that they've asked for, plus $1 million in punitive damages, and now you're not going to cover it because punitive damages aren't covered under insurance. So I want you to settle this, and because they're asking for something that's within my policy limits, you can push the insurance company to settle the case so that there's no, you don't have to take this risk that they're not going to cover you for.
Right.
And that's where you really want to get a lawyer involved, because insurance companies, avoid paying at all costs.
So that's and we did an episode about that. So I think folks should definitely listen to that, because it's really, really important to understand that and this goes into a different episode we recorded about using AI as an attorney, right? And it's just the idea that having the experience and expertise to look at all these different pieces and make decisions based on the actual, all the different parameters of the case. You might be 100% right, and you have this insurance, but the way the insurance is drafted and written, you're better off settling, as you just said, than you are taking this to the wire, because you have that insurance policy for a reason. That's why you're paying for it, right? And so understanding that, having an attorney help you navigate that based on what they know is, hey, here's your percentage chance of winning. Here's what we see. Here's what we see in our experience. Here's what your actual insurance premium is. Here's what your actual insurance policy is, your deck page, et cetera. Man, that is so critical to have a steward that's going to guide you through those things, because it's not necessarily black and white.
Yeah, don't be penny wise, dollar foolish on something like that, right? Because you'll spend, look, if we're overseeing your insurance company, you're not going to spend as much money on us because we're not going to be doing the busy work.
Right.
But we're going to be like, hey, maybe they should be doing this. So it'll really be some helpful strategic things to really help you. Another thing, you brought up AI. I think this is a good closing point and important thing to cover. Sometimes you'll say to the employee will come to you and say, hey, you're going to fire me, give me a severance, right? And you're going to sign a severance agreement, and you're going to be like, I don't need a lawyer for this. I'll sign a basic severance agreement with the employee. Make sure your severance agreement has a very strong CEPA waiver and release, because what winds up happening is it's very hard to release these kinds of things, because the government doesn't want you to release them. The government incentivizes you to bring these claims. And so if you're the employer and you're saying, I have no claims, or you're asking the employee to say, I have no claims in exchange for a big payment now, make sure that agreement's airtight. Don't just write that using AI.
Okay. Yeah, that's a great point, because employees have a year, right? Statute of limitations a year on these things, and they can obviously bring these claims after employment, right? They don't have to be working for you to bring that employment, but you can write a severance agreement that actually, because I thought that there was, maybe it was New York, I thought there was somewhere where they said that you can't do that anymore. Like, you can't waive your rights in those.
Well, what you can say in those agreements is, for instance, that you're acknowledging right now that your employment, that you're voluntarily leaving,
right,
and that you're not being retaliated against and you're not being fired. So if you've acknowledged that in a document correctly, then arguably for you to wake up later and say, well, wait a second, I got paid 3 months salary or 6 months salary to leave, said that I'm not being retaliated against, said I'm leaving voluntarily. Now you're changing your testimony, sir?
Yeah.
You see what I'm saying?
Got
so it really does. There's a lot of ways to close those doors.
Okay. I think that is super valuable. If you're an employer in New Jersey, CEPA could have major ramifications on the future of your organization. I think it's really important that if you stuck around this long, that you watch this entire video, hit it.
I got one more thing to say. You just made me reminded. Because when you said in New Jersey, be very careful with one more thing, and you should really consult with a lawyer about one more thing. A lot of people have remote work now, right? A lot of people have multiple locations, right? So my headquarters could be in Pennsylvania, and I could have a remote employee in New Jersey. And if I retaliate against that remote employee in New Jersey, CEPA protects them. So you got to be real careful about that too. Or let's say I really don't, the employee lives in Philly, my office is in Bucks County, but I have this employee, regularly going to New Jersey to do some sort of tasks. CEPA might protect them. There might be a good argument about it. It depends.
Wow.
And so again, this is a big, it depends. And it's something you definitely want to talk to a lawyer about, and you really want to be careful.
So just because you don't pay that toll when you go into Jersey out of Pennsylvania doesn't mean you're not paying that toll. You know what I'm saying?
On the way out.
Yeah.
Right. On the way out.
So I would say employers, just to recap, glad you stuck through to this video up to this point. Think it's super valuable. I'd say head over and watch the employee-centric version, because you want to know what they know and what they're thinking about and understand from their perspective. And it's to protect yourself, but it's also to understand the full ramifications, because there is good intent here, right? The good intent is to protect employees who are trying to do the right thing. And I think it will reward business owners that are also trying to do the right thing.
Yeah, and if there's one thing to say, it's don't make those rash decisions, right? You get a report, you want to blow up, you want to say no, and start, taking action. Sleep on it. Talk to a lawyer. Spend a little bit of time before you respond. Thank you for bringing this to our attention. We'll be right back to you.
Yep. Thank you for bringing this to our attention, and we'll be right back. Anton, thank you so much for sitting in on the podcast again, and appreciate you.
Have a good one.